This is now the part 2 of our discussion of the rules of procedure for environmental cases. So for your environmental case, the first step is that the plaintiff will file his verified complaint. So dun sa first video, we discussed who is our plaintiff. Just take note of the citizen suit, importante yon, and in what court you are going to file your environmental case. Answer is either MTC or RTC, depending on the law involved, and also you check the rule on the filing fees kasi magkaiba sila ng rules. Take note also of your Section 6 of Rule 2. What is Section 6? Ano ang nakasulat? Upon the filing of the complaint, the plaintiff is required to furnish the government or if there is an appropriate agency, even though they are not a party to the case, a copy of the complaint. And proof of service upon the government or the appropriate agency shall be attached to the complaint. So after the filing of the verified complaint, what will happen next? The court now, whether this MTC or RTC, will issue summons. So sa summons, ang dapat itanong is, first, who may serve the summons? And second, how do you serve your summons? So who may serve summons? In your environmental case, the answer can be found in Section 13 of Rule 2. Summons may be served by the sheriff, his deputy, other proper court officer, and also if there is a justifiable reason, then the counsel of the plaintiff is allowed to serve summons as well as the representative of the plaintiff. Take note of number 5. Yung number 5 is kakaiba because a suitable person, as long as that suitable person is authorized or deputized by the court, then that person can also serve summons. This suitable person, take note, pwede yan maging private individual. He can be a private person. And in that case, if it is a private person, if he is a private person, rather, deputized by the court to serve summons, then for that purpose, he is considered as an officer of the court. If we will compare this to your ordinary civil case, under the 2019 amendments, Section 3 of your Rule 14, sino ba ang pwedeng mag-serve ng summons sa isang ordinary civil case? Answer is the same. Pwede si sheriff, pwede yung deputy ni sheriff, or the other proper court officer. But take note that under the 2019 amendments, the plaintiff also can serve the summons. But hindi counsel ni plaintiff, hindi representative ni plaintiff, but the plaintiff himself. But ano ang kondisyon under the 2019 amendments? First is, the court may authorize the plaintiff to serve the summons, but together with the sheriff, only in case of the failure of service of summons by these three. So kung hindi na-serve ni sheriff, ni deputy, ng other proper court officer, then that is the time that the court may, the word used is may, the court may authorize the plaintiff to serve the summons but together with the sheriff. Meron pang another scenario wherein the plaintiff is allowed to serve summons, and that is in cases where the summons is to be served outside the judicial region of the court. So let us just say that you have a case pending in Metro Manila, that is the National Capital Judicial Region, but your defendant is in Baguio. So definitely he is outside the National Capital Judicial Region. So in that case, ano ang sinasabi ng 2019 amendments? The plaintiff shall be authorized to cause the service of summons. Take note, the word used is the plaintiff shall. The plaintiff shall be authorized to cause the service of summons, and this time, wala nang kasamang sheriff. Who else can serve your summons under the 2019 amendments? This one, the counsel of the defendant. Basis, you read your Section 13 of your Rule 14. where the summons is improperly served and there is a lawyer who makes a special appearance on behalf of the defendant, and among others, he wants to question the validity of the service of summons, then the counsel now shall be deputized by the court to serve summons on his or her client. So under the 2019 rules, ito lamang ang pwedeng mag-serve ng summons. While in your environmental case, take note, any suitable person, as long as that suitable person is authorized or deputized by the court, then he can serve summons. Next question, how is the service of summons effected? Answer is through personal service. Second, you can resort to substituted service. Third is summons by publication. Ano ang requirement ng summons by publication in your environmental case? The answer can be found in Section 13, Rule 2. Kung meron lang failure sa personal and substituted service, then you can resort to summons by publication. Again, should personal and substituted service fail, then summons by publication shall be allowed. Let's compare this again to your ordinary civil case. Ano ba ang sistema sa ordinary civil case? How do you serve your summons? It's the same. First, there must be a personal service, which is the ideal, yan yung preferred. Next is substituted service. And last is summons by publication. But if we are talking about an ordinary civil case, hindi basta-basta ang summons by publication. Mahigpit ang requirement dyan. Dapat you must comply with the conditions. For natural persons, the applicable section is Section 16, Section 17, and Section 18 of your Rule 14. And for juridical persons, then you have to read Section 14 of your Rule 14. We will discuss this, mag-segue tayo dito. So, in an ordinary civil case, how do you serve your summons? First is personal service. The accurate term is, according to Section 5 of your Rule 14, service in person on defendant. And how do you serve in person on defendant? You serve it by handing a copy to the defendant in person and informing the defendant that he or she is being served. And if the defendant refuses to receive and sign, then you leave the summons within the view and in the presence of the defendant. So your personal service is the ideal at yan ang preferred. Kung may hierarchy, ito ang number 1, pinaka-importante. But if you cannot effect personal service, then the law allows you to serve or to effect substituted service. That is your Section 6 of your Rule 14. The reason why we are discussing the service of summons in your ordinary case is, this is a favorite bar topic. Sinisingit lang natin para makita nyo yung difference. So sa substituted service, according to the 2019 amendments, if the defendant cannot be served personally after at least 3 attempts on 2 different dates, this is your Manotok case. So if there is at least 3 attempts on 2 different dates, then you can leave now a copy of the summons at the defendant's residence, as long as you leave it to a person at least 18 years of age and of sufficient discretion residing therein, or kung hindi nyo mahanap sa kanyang bahay or sa kanyang residence, then you can leave a copy of the summons at the defendant's office or regular place of business, or you can leave it to the officers of the homeowners association or condominium corporation or sa chief security officer in charge of the community or the building. And last is, you can send it also to his email address if it is allowed by the court. So how else can you serve your summons? You can serve it by publication. This is a favorite bar topic, kaya i-discuss natin ng maayos. So, if ever you will be confronted with a question, bar question, or in your midterms or finals, and ang tanong is the service of summons by publication applicable, then what is the tip? The tip that I will be sharing to you is ask yourself first, who is the defendant? Who is the defendant in that question? Is the defendant a natural person or a juridical person? Unahin natin si juridical person kasi mas madali. Pag ang defendant sa problem is a juridical person, sino ba itong mga juridical persons? That juridical person could either be an entity without juridical personality. Nagpapanggap na corporation pero hindi naman pala registered, hindi rehistrado. Or it could be a private corporation or it could be a public corporation. Pag private corporation ang involved sa problem, then maging alerto ka. Ask yourself, what kind of a private corporation is involved? Is it a domestic private juridical entity or is it a foreign private juridical entity? Pag foreign private juridical entity ang involved sa problem, mas lalo kang maging alerto. Again, you ask yourself, is it a foreign private juridical entity which is doing business in the Philippines or has transacted in the Philippines as defined by law? Or is it a foreign private juridical entity which is not registered in the Philippines or walang resident agent sa Pilipinas but is doing business in the Philippines or has transacted business in the Philippines? So, in this case, sino ang pwedeng iserve ng summons by publication? Only the foreign private juridical entity not registered in the Philippines or has no resident agent in the Philippines but has transacted or doing business. Take note ha, ito lang ang pwedeng iserve ng summons by publication. How about if the defendant in your problem is a natural person? So, paano aatakihin? This is my tip. First, ask yourself, does the plaintiff know the name or the identity of the defendant? Bakit? Kasi kung hindi niya alam ang pangalan, he does not know the identity of the defendant, then you can serve summons by publication. You can serve summons by publication. May magtatanong sa inyo, bakit attorney, pwede ka bang mag-file ng isang kaso sa tao na hindi mo naman kilala or hindi mo nga alam ang pangalan niya? Answer is, yes. If you're going to read your section 14 of your rule 3 sa civil procedure, ano ang sinasabi ng section 14? Whenever the identity or the name of a defendant is unknown, the law still allows you to sue that person, and that person will be sued as the unknown owner, heir, devisee, or by such other designation. And if you know now his name or his identity, then you will be amending the pleading accordingly. Just to give you an example, no, para mas lalong maintindihan. Sa office, we have this client who inherited properties from his parents. And the properties are located in Metro Manila. The first lot is around 800 square meters and the second lot is 500 square meters. So, substantial yung mga properties. So, hindi mo pwedeng pabayaan. But the problem is, merong mga naka-squat dun sa properties. At itong aming client, when he went to us, ang kanyang problema is, he does not know the names of those occupying the properties. Hindi pa nga niya na-meet, hindi niya kilala, wala siyang idea kung sino ang mga nakatira doon sa properties na yon. So, can we still sue those occupying or those persons occupying the lots? Answer is yes. The law allows us to sue those persons. That is what section 14 is telling us. But going back to that client, Since ang ifa-file namin is unlawful detainer, the requirement of the law is you have to give first a demand letter. At mahirap magbigay ng demand letter na hindi mo kilala o hindi mo alam ang names. Kaya ang nangyari doon, naging innovative kami. Yung aming mga kasamahan is nag-post as somebody from the post office. So yun, nakuha ang pangalan, and in the long run, na kapag file ng kaso against those squatters. Paano pa aatakihin ang problem if the defendant is a natural person? Aside from asking whether the plaintiff knows the name or the identity of the defendant, ask also whether the plaintiff knows the whereabouts of the defendant. But take note ha, kahit hindi mo alam ang whereabout ni defendant, ano ang requirement ni Section 16 of your Rule 14, hindi lamang the whereabouts are unknown, but the rule requires the plaintiff to ascertain by diligent inquiry the whereabouts of the defendant. And in that case, dun ka lang pwedeng mag-serve ng summons by publication, and you need to secure leave of court. Take note ha that itong Section 16 applicable in any action, applicable kahit anong kaso. So again, paulit-ulit ang atake if confronted with a bar question. If the defendant is a natural person, the first thing that you need to ask is, kilala ba ni plaintiff si defendant, or does plaintiff know the whereabouts of the defendant? Bakit? Because if the answer is in the negative, then you can serve summons by publication. You can serve summons by publication. Next scenario. Paano naman kung kilala naman ni plaintiff or alam ni plaintiff ang pangalan ni defendant, or plaintiff knows the whereabouts of the defendant? In that case, hindi ka pwedeng mag-serve ng summons by publication. Hindi ka pwedeng mag-serve ng summons by publication. Because remember, your summons by publication is a last resort. Kung pwede nga lang, huwag kang mag-serve ng summons by publication. Ayaw ng batas. But the law allows you to serve your summons by publication as long as you comply with the requirement. So there are two instances wherein the law allows you to serve summons by publication even if you know the name of the defendant, or even if you know the whereabouts of the defendant. And that can be found in your Section 17 of your Rule 14 and in your Section 18 of your Rule 14. Section 17 applies to defendant who is not a resident and is not found in the Philippines. Number 2, or your Section 18, applies to a defendant who ordinarily resides within the Philippines but who is temporarily outside of the Philippines. Example nito, itong yung mga OFWs, mga resident ng Pilipinas, pero wala ngayon kasi nandun sa Saudi Arabia, sa Japan, andun nagtatrabaho. Then they are temporarily outside of the Philippines. Another example is yung mga nag-take ng MBA, nag-take sa London, pumunta, doon nag-aral, so they are temporarily outside of the Philippines. Another example is, especially ngayon ng COVID, yung may mga pera, yung allowed to stay in another country, doon sila nagpuntahan kasi they are allowed to go out, mas free to roam around, walang restrictions, walang lockdown. So they are resident of the Philippines but temporarily outside of the Philippines. So in these scenarios, service by publication or summons by publication is allowed. When you read your Section 17 of your Rule 14 of the Civil Procedure, this is the extra-territorial service, relate it to Section 3 of your Rule 4, the venue of actions against non-residents. Madali lang i-recall si extra-territorial service. For Section 17 to apply, ask yourself who is the defendant and what kind of action is involved. If your defendant is a non-resident, and is not found in the Philippines, then pwedeng pumasok si Section 17. But huwag kang hihinto doon. Second, you need to ask yourself what kind of action is involved. Is it one which affects the plaintiff or one which affects the defendant? Pagdating kay plaintiff, dapat titingnan mo kung yung action affects the personal status of the plaintiff. Pagdating naman kay defendant, ang dapat mong titingnan is, does it affect the property of the defendant and that property is located in the Philippines? Ano ang ibig sabihin niyan? Yung property ba ni defendant has been attached or yung subject matter ba sa case is a property wherein the defendant has a claim or interest, or pag binasa mo yung prayer ng action, is it one which wants to exclude the defendant from his interest in that property? So that is your Section 17. So in your Section 17, if it falls under that condition, then you are allowed to serve summons by publication, but you need to secure leave of court. Just take note ha, hindi lamang summons by publication, you need to send a copy of the summons and the order of the court to the last known address of the defendant. That is the requirement. For Section 18, residents temporarily outside of the Philippines, then you can use this in any action. Take note ha, kahit anong klaseng kaso. But you need to secure leave of court in order for you to serve summons by publication. So this is the summary of what we have just discussed. If your defendant is a natural person, then ano ang atake again? You ask yourself, kilala ba ni plaintiff ang name ng defendant or yung identity ni defendant? Kilala din ba or alam din ba ni plaintiff ang whereabouts ni defendant? If the answer is in the negative, then you can serve summons by publication. Take note that it is applicable sa kahit anong kaso, any action. But if the plaintiff knows the name or the identity of the defendant, or the plaintiff knows the whereabouts of the defendant, then you do not serve summons by publication. Dalawa lang ang instances wherein you can serve summons by publication if you know the name or you know the whereabouts, and that is your Section 17 and Section 18. Sa Section 17, the defendant does not reside and is not found in the Philippines, but you have to qualify because it does not apply to all cases. And in Section 18, the defendant is a resident of the Philippines but temporarily outside of the Philippines, and this applies to any action. And the requirement of the law is not merely summons by publication. You need to send a copy of the summons and order of the court to the last known address of the defendant by registered mail. So I hope sana by this time clear na sa inyo kung paano aatakihin ang question, especially in the bar exams. So ang layo ng inabot ng ating discussion, I just need to discuss the service of summons in your ordinary case or your ordinary civil case, because this is a favorite bar topic. Baka makatulong sa inyo yung aking discussion. So this is already a 24-minute video. I will stop here. The next discussion is the verified answer. And before I go, let me just say daghang salamat. Maraming salamat. Thank you very much for subscribing to my channel. And if you are new here or hindi ka pa nakakapag-subscribe, please do so. And for those who are leaving their comments, I assure you that I read them and actually it inspires me. They help me motivate to make videos. Minsan kasi tinatamad din akong gumawa ng videos. Iniisip ko wala namang nanonood or sayang lang yung effort. But after reading your comments, after reading yung experience nyo, then it motivates me to produce more videos. So maraming salamat and have a good day.